welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me today I've got Nunzio Tartaglia, partner in a law firm in insurance law. Good evening, Nunz.
Evening, Tony. Evening, viewers. Welcome.
And Jessica Rosla, senior lawyer in insurance law in the law firm. Good evening, Jess.
Evening, Tony. Evening, viewers.
Tonight, viewers, we're going to give you an update on insurance law and some very interesting cases that do affect you. So stay tuned for that.
Before we kick off, though, Tony, what's in the news?
Well, Nunz, Jess, there's been a lot of stories. The first one's about a doctor, Dr. Tickle. He's a very famous celebrity doctor. He's raised concerns about the use of mobile phones and that they cause brain cancer. What do you say about that, Nunz?
Well, he's saying it's the next big sort of tobacco issue, and it's it opens up a can of worms if it is proven true that basically the radiation's causing cancer, and so the telecommunications I suppose board or association are denying it all, obviously, but where it goes, I'm not sure.
Well, Jess, he's promoting this new device called Patched. Mm-hmm. It's advertised to reduce harmful radiation from your phone. You actually attach it to your phone, and it's relatively cheap in terms of pricing, but it reduces radiation. And in the States, there's already been stories of people suing for cancers due to radiation. Yeah. Do you think there's any legs with this, or?
Yeah, look, certainly, Tony. It's interesting. I think there's always been studies about whether the radiation can cause brain cancer, and I think Dr. Tickle has a vested interest in it, being a brain cancer survivor himself. So certainly I think it's a good incentive, and he's made some relevant points about telecommunications providers providing consumers with advice about keeping the phone a certain distance from you to ensure safe use. So I think he's got some good grounds in promoting his product there.
And once I met up with him and he told me that in his opinion, the brain cancers he's got and also were due to the radiation and stress.
So
that's pretty interesting.
If that's proven correct, then I said it opens up a massive can of worms and something that'll be in litigation for years. But we'll see.
Viewers, will get him on the show and we'll let him explain what this device is. Now, Nunz, this is a really, really sad case. A young boy was killed by a homemade gun. Yeah, so isn't that sad?
Yeah, it is. Look, Daniel Cowan was on a friend's property with his twin brother, or his brother and a mate, and unfortunately he was accidentally shot by an air gun that the sibling of his mate's dad had at his place. And look, it's an unfortunate event, but one that did occur. And look, he was in hospital, I think, for a week when he eventually passed. And now the family is suing basically the kid, his parents, basically for the having an air gun at the place and for allowing an unsafe premises.
Well, Jess, it's almost criminal. The gun was powered by a high-pressure compressor capable of firing projectiles at dangerous speeds. Yeah. I mean, an air gun traditionally could hurt you and sting you. Yeah. To actually kill you, that's unheard of.
And I think the crucial part here is, Tony, boys at these age, 15, 16 years old, the young boy knew his dad had the gun at the house. It wasn't locked away, and as young boys do, they get a bit excited with these kind of things and thought they'd have a bit of fun with it. But unfortunately, they weren't adequately supervised, and then it turned into a tragic event.
I reckon it's criminal, Nunz.
Yeah.
Well, look, he's pleaded guilty to obviously holding an illegal firearm at the place, and look, I think unfortunately, by way of a case, I think unfortunately the Cowan family doesn't want.
It's criminal negligence.
Yeah, look,
personally, it's more of a manslaughter case.
The Cowan family doesn't want it, but I think they're going to succeed in whatever damages they're seeking.
It'll be nervous shock, won't it?
Yeah. It's incredibly sad.
Yeah.
WorkSafe's under fire, Jess.
Yep.
Apparently, there's been a lot of people complaining to the Ombudsman when their claims have been either rejected unnecessarily or disputed unnecessarily. And so everyone seems to be going to the Ombudsman, and the Ombudsman's come back with saying that, a lot of these cases should have been accepted in the first instance. Yeah,
that's right, Tony. I think it's great that the Ombudsman is finally giving injured workers a voice in these cases, particularly in circumstances where I think the findings have been that a lot of evidence hasn't been considered, and in that regard, the decisions haven't been reviewed, which often workers struggle with.
Yeah, of course.
Yeah, so I think it's a good investigation, and it'll be interesting to see what they find.
Well, Nunz, in the 2014-15 financial year, there was 370 complaints. And one of the major complaints was a failure to make a decision. And it's pretty tragic when you're dealing with families that are relying on these benefits to survive.
That's right, they're off work, they need medical expenses, they need weekly payments, and if they're struggling to get access to that, which is a right that they have, again, I think I welcome this investigation by the Ombudsman, because if they're being delayed unnecessarily or without merit, that just can't happen. So, look, WorkSafe, that they're welcoming the investigation, which I suppose I have to say.
Yeah, of course.
But really just to see, that I think there's 370 complaints in the last financial year. I'm interested to see what increase in complaints the previous couple of years, because I think that will give an indication of maybe the trends. But look, it's an investigation that hopefully bodes well for workers.
And also, I guess, there could be more complaints, or less, depending on whether people are aware that the Ombudsman's there, you know what I mean? A lot of instances people don't even know the Ombudsman
that's a good
exists.
point.
Yeah. Anyway, look, we can keep a tab on this in the future.
Yeah.
Another tragic incident at a chicken farm, where a particular worker was very, very severely injured. Jess, tell us a bit more about Leonica and Golden Farms.
Yeah, so this is, as you said, Tony, a really unfortunate incident at a processing factory, effectively, where the worker's arm got caught in a machine where she says she wasn't properly trained in it and the machine had no guard.
Yep.
And her arm was caught in there for about an hour while the machine was still going, and unfortunately suffered some pretty nasty injuries to her arm, including disfigurement and scarring, and as a result, psychological injuries flowing from that, Tony.
The company was convicted and fined $64,000. Is that a pretty heavy fine, or?
Look, I think it's heavy in terms of what the legislation provides for, but in terms of the outcome for this worker, clearly no. And it's just, it's a really sad case. And, for the fact that, a $400 guard could have prevented this, look, to be frank, it's just not $64,000 enough.
In this day and age, it's no excuse.
It's no excuse. So, I hope she gets the compensation she deserves and puts her back to some normality, but she'll never be back to normal.
No, you'll never be the same again, will you?
Unfortunately not.
But it's a good case.
Yeah.
VicRoads loses bid to avoid charges in worker death. I mean, this is extraordinary what they're trying to say here, Jess. Tell us a bit more
I
about
agree.
it.
Unfortunately, in this case, Tony, tragic circumstances again. A worker was working on the road and was run over by a street sweeper, and unfortunately died at the scene. And VicRoads are trying to argue that the state occupational health and safety laws don't apply to them effectively, being an on-road work site, and also on the basis that they have their own plan in place.
Nunz, they face fines of up to $1.1 million. But surely, if that was you or me, it would be charged with some sort of culpable manslaughter, right?
Look, I agree.
Why shouldn't someone be charged over this?
What annoys me, probably the right word, frustrates me with this is that the technicality which VicRoads are trying to fall under means that they'd only pay a fine of up to $7,000 as opposed to $1.1 million. So this is a monetary issue for them, and that, to me, that's ridiculous.
It's
considering
scary that they're not even considering the personal, implications of someone actually dying.
Exactly right. And
Yeah.
when, as you said, if you and I, hit someone on the road or
Would be
to that
visiting
effect,
each other at Majesty's pleasure, huh?
that's right.
Yeah.
So it really, I've got to say, it doesn't sit well with me, and I think it should just be paid and move on. And so they did lose at the Court of Appeal. I'd be really disappointed if they take it any further.
Yeah.
And Justice Weinberg in the Court of Appeal said the exemption was utterly improbable.
Yeah.
Which is
That's
reasonably
pretty
stern, I
definitive,
guess.
isn't it?
Yeah.
Look, viewers, we've got to go to a sponsors break. Stay tuned. After a break, we'll give you an update on insurance law. Viewers, welcome back to the show. We're going to give you an insurance update today. But firstly, I want to raise this issue of if you rent a place with Airbnb, what are the implications? No, in this particular case, Zach Stone, a fellow died, and there's issues of insurance and everything else.
So in this case, an American man rented a place through Airbnb in Texas. While there was a swing which unfortunately collapsed or fell apart, however you want to call it, and he landed on his head and died. And the family, the family did pursue compensation through the actual occupier of the house that they rented, not Airbnb. But the issue is, I suppose, brought into play. The involvement, is it both the occupier and Airbnb or just the occupier itself? It brings it into really different issues, considering Airbnb is so widely used.
Well, the real risk, Nunzio and Jess, is that there could be some issue with the occupier running a commercial business. The insurance company might not pay, might not indemnify.
Yeah.
Because they'll say, why didn't you tell us you're running it as a commercial enterprise?
Yeah, and that's the real crucial part, Tony, particularly if, I guess it raises the questions, what happens if it occurs in Australia, being relevant to where we are. And I believe Airbnb have their own public liability insurance, Tony, but it's only coverage up to $1 million, which is about a tenth of, or even less, of what a normal PL or public liability coverage would offer.
Well, if Mr. Stone had survived, Jess, with brain damage, you'd hazard to guess based on figures, that we've dealt with over the years, that $8 million wouldn't be enough to keep him, to look after him.
That's right.
Over his lifetime.
Yeah, certainly.
So $1 million won't take it very far.
No.
But I guess it also means that you, as someone that wants to rent through an Airbnb, should be asking questions about insurance, shouldn't you?
Yeah, you've got to actually inquire. Say, look, one is the host occupier. Do they have insurance if something happens? And two, do Airbnb may confirm their insurance coverage, because something innocuous can happen, and these incidents show that. And you don't want to be going on a holiday of your life and then coming back injured and not being able to get compensation for it.
Exactly. Exactly.
And Airbnb is becoming widely used because it's a cheap form of accommodation. That everyone's employing.
Well, just on that note, if anyone ever gets stuck, they should ring you.
Yeah, of course. Look, that's why there's a lot of different sort of insurance issues and complications, and you need to know exactly who to sue and who the responsible party is. So
Jess, 1300 injured?
Yep.
That's
Give
it.
us a call.
All right, Rockdale City Council and Simmons. It's a New South Wales decision of 2015. Jess, want to give us a bit of the facts?
Yeah, so Tony, this is a Court of Appeal decision. So just briefly, the person who, or the plaintiff who's now the respondent in this case, was effectively injured when he was riding his bike through a boom gate and effectively collided with it. And the concern was whether or not he'd contributed to his injuries, so what we call contributory negligence. And ultimately, the court found that there was no finding for contributory negligence here, in the sense that there was a perception issue where the boom gate looked the same when it was closed and when it was open. So there was no way the cyclist could have known the difference.
Nunz, this is a classic council case, right? And there's all sorts of provisions in our legislation, and also the New South Wales one, Section 43A Civil Liability Act, which mirrors our Wrongs Act, right?
Yep.
It is such a complicated area of law, isn't it?
Look, council cases are, I think, probably beyond medical negligence cases, are probably the most difficult cases, I think, almost in personal injury, because they're so convoluted. It's not a straightforward negligence argument. Council have got defences, they've got plans that they can stick to. It's just not a simple cases, and that's why they're very, I suppose, fiercely defended by councils.
Yes.
And also, from our end, we have to put so much work into it.
Well, they've got a lot more protection than the average person.
Yeah, so the reason why, to give a bit of background to viewers, is that they've got a bit more protection than, the normal occupier, like a shopping centre or a supermarket, is because effectively got to a stage where they were getting sort of sued too much, and they couldn't keep up with the insurance coverage or the excesses, and that's why I think the government said, well, we've got to sort of manage this a bit better, and they've afforded them protection. For example, like a resource defence, they can't attend to everything because it's just going to be too expensive.
Well, it's a case of, we go back to the old common law principle of misfeasance, non-feasance.
Yeah, exactly.
And, whether they've turned their mind to a particular problem that's been raised, and if they haven't turned their mind to it and gone out to fix something and done it incorrectly, then you've got a very limited chance of suing unless they've failed to inspect. That's very brief. So you really should consult lawyers when you're dealing with these sorts of cases because they're very complicated. Just quickly, before we move on from this case, the court found that the council was liable, but what did the club wasn't the club responsible?
So the boom gate was an entrance to a sailing club, Tony, and whilst the sailing club had some exercise of control over the operation of the boom gate, the court found that it was a relatively informal agreement with the council. So in that regard, they may not have been aware of the boom gate being an issue for cyclists, whereas council knew that previous incidents had occurred of this nature.
And the council were the owners of the land too, weren't they?
Yeah, well, they had the interest in the land, that's correct.
Yeah. All right, we'll keep moving. Kennedy and Sheriff Campaspe, Victorian Court of Appeal decision, 2015. This is right on point, Nunz, in relation to what we're discussing about the Road Management Act and also the Wrongs Act and all the defences available to council.
Exactly right. Look, Tony, this has sort of changed the landscape in council cases in Victoria, and it's a pretty big decision, and one the Court of Appeal this year, so it's on point as ever. And just before I sort of kick off, my understanding is that the council sought special leave to the High Court to effectively review this decision. So there might be more to come out of this one, but we'll see. But effectively, the facts of this is that Miss Kennedy was suing the Shire Campaspe for tripping on a lip on a footpath where she injured her wrist, and initially she lost the trial because basically the judge found that the defences that the council had available to them were upheld and they could rely upon those. And then it went to Court of Appeal, which look, it's a long case, but
Just on the issue of what did she lose in the first instance, Jess, before a single judge?
So effectively, Tony, as you mentioned with councils, the real question is, have they inspected within a relevant time?
Yep.
And in this case, the council had inspected about 2 days late in relation to the footpath. However, the court found that inspection effectively cured the breach. So the argument then flows that, well, even if they had inspected it, even though they had inspected it 2 days later, it wouldn't have made a difference to the client's injuries or the incident occurring. So in that regard, that they could still have the protections at law, and they relied on those.
Well, it's very technical, Nunz, and there was a lot of debate about how big the lip was.
Yeah.
Was it 10 millimetres, 20, 30? Look, we'll get back to the Court of Appeal decision after the break. Viewers, we've got to go to a sponsors break. Stay tuned. Viewers, welcome back to the show. We're talking about these very complicated cases involving councils, sailing clubs and bowling clubs and whatever else is out there that's governed by council rules and regulations. Nunz, it just highlights that whenever you get injured in circumstances where there's a council or you have to apply road management rules, you must get legal advice.
No doubt about that, Tony. And look, this case of Kennedy is proving point where if you didn't have, to be frank, a lawyer involved, you wouldn't have known the issues that are at play. And more evidence came out down the track about what their actual policy was, and that if you didn't press that through a lawyer, you would never find information. So it's crucial as ever.
It's crucial. And Jess, of significance, here you need to know certain bits of evidence that if you don't get it early in the piece to preserve it, like, police setting up the barricades and whatever, you're really going to be, put yourself in a situation where you will struggle later on, correct?
Yeah, that's exactly
So you
right.
need to get onto it really, really quick.
100%.
All right, and on that note, Nunz, Court of Appeal in short, what did they say in this decision?
Well, all they said was that they disagreed with the trial judge and believed that the breach of the road management plan was not cured, and effectively they remitted it back to the county court for trial through common law principles, Tony. So basically they can't rely on the defences in the Act. So it's just pure common law principles. Are they negligent, and did that negligence cause the accident? And we'll see how that pans out.
What do you think will happen, guys?
I think if it's a negligence argument, I think they'll probably get up, and they don't have the defences available to them. So I think this will settle.
I think it should settle because by now they've already outlaid over $500,000, correct?
Yep.
More than enough?
Yep.
Okay.
But we'll see if the special leave comes through. They might wait on that.
Yeah.
Okay, we'll see what happens. Anyway, there's implications that flow from this. Jess, can you give them in brief?
Yeah,
Or,
yeah. Well, certainly, as Nunzio said, the real, I guess, advantage or clarity that we've obtained from this judgment is that if there is a technical breach, then council doesn't have the protections that they would have originally had through the legislation, Tony. But the real question is whether that breach has caused the client's
any
injuries.
damage? Yep.
So that's still up for contention.
You've still got to show there's a causative link.
Exactly.
Yep. All right, let's move on to the next case. Tilden and Greg, New South Wales decision 2015. Nunz. The facts?
Basically, the appellant in this case was punched in the face by, his name's Mr. Greg, at the Ettalong Bowling Club. And effectively, he's issued proceedings against both Mr. Greg and the bowling club for damage sustained through the punch.
All right.
Yeah.
And Jess, what happened there?
So Tony, the plaintiff Tilden was successful against Mr. Greg, who assaulted him, but not against the club. So effectively, the arguments were that if the club had more security on board, or if they should have been on notice of the person who assaulted Mr. Tilden of his quarrelsome behaviour, then they could have prevented the incident.
So in effect, they're saying just that if this fellow was known to the club to be a troublesome person who'd come there on regular occasions and caused these sorts of incidents in the past, in no circumstance the club could be held liable. There's some significant implications for the plaintiff in this case, because you as a plaintiff lawyer, you don't want to get judgments against individuals, do you?
No, because look, the fact is, I think 9 out of 10 individuals don't really hold much by way of assets in their name or money. It just doesn't happen. So
there's probably no insurance.
That's right, and one, they've definitely got no insurance for it. So especially considering Mr. Greg, I understand, pleaded guilty to the or was charged. There's no way any insurance is going to cover him. So trying to extract any monies from him, which I think in this case about $37,000. I know that's not the biggest settlement we've ever seen, but that'd probably be a tough task to get it.
It could cost you $37,000 to try and get the $37,000. That's the problem.
So,
what is amazing out of this is, in what circumstances, Jess, do you think the club would have been held liable?
I think, Tony, if the evidence showed that this person was mentioned in kind of, your monthly meetings with the club, and that security had incidents involved with him before, that would be a telling factor that they need to keep an eye on him when he's around.
Or exclude him.
Exclude,
he's one of those types that you don't want in the club. Just curiously, how many times would his name have to pop up before there's an exclusion on him?
Look, if he's a regular, I think in one meeting's almost enough, to be honest with you. And even on the night, if there was issues with respect to him on the night that they felt like we have to keep an eye on him, then I think you could almost have a case against the club. But the evidence showed that he was just there and it happened and
suddenly.
You can't protect everything and prevent everything from occurring.
But he did come across as being a regular at the club.
He was, but didn't pose any particular trouble. So it's a fine line, but that's where you've got to probe the defendant for evidence and say, well, we want to know more about him.
And once it kind of highlights what I said, you need a lot of evidence early in the piece.
That's exactly
so you can't wait in these cases.
Definitely.
Saying that though, I think Mr. Tilden, who got hit by Mr. Greg, didn't help the situation when I think he accused him that he could only hit disabled people or women.
So what, he tried to prove him otherwise?
Yeah, and that's why he didn't get aggravated or exemplary damages. So,
You know what I mean? You still, even though you say stuff like that, you're not going to go bolt.
No, but
Viewers, we got this other case we want to take you into, Parkour in the city of Bankstown. Well, they're all New South Wales, 2015. What are the facts of this case, Jess?
So Tony, in this case, Mrs. Parker was attending a dance studio to watch her daughter perform effectively in a concert, and unfortunately she sustained a fall down a set of stairs. And there were two issues here, Tony. One being, the main issue was what caused her to fall, and there were two possibilities. One being whether there was an object on the floor that caused her to fall, or whether the stairs weren't properly illuminated.
Which is always an issue in these cases.
That's right. Which, unfortunately, really crystallised in this case when the judge looked at the evidence and found it was more likely than not that the stairs were properly illuminated.
Well, Jess has already alluded to what happened.
Look, she wasn't successful and obviously couldn't prove liability or negligence against the RSL, but, they found that, one, there was slip strips, and two, it was properly illuminated and, didn't need to be more illuminated. And despite the plaintiff, engaging expert evidence, it wasn't to any advantage.
The judge then went on to do an assessment of all the different heads of damages.
That's right.
They probably, a lot of them, don't relate to Victoria, but actually they do relate to Victoria.
Yeah, look, the plaintiff would be pretty upset reading this because she would have been awarded close to just under $600,000 if she was successful. So it's quite a big damage for a public liability case.
Well, look, I want to go through these various heads so that the public knows what we're dealing with, Nunz. Past and future gratuitous care. What's that all about?
Well, effectively, that's for things that she was doing prior to the accident that she can no longer do, and now she needs the assistance for, and she was awarded damages for that.
And is that done by outside help, or is that family members?
Usually, it's more like family members, but also we can use the evidence of getting outside help.
And so, Jess, you can get a family member to charge at say $30 an hour to do the things that you could have done.
Yeah.
So it could be a pretty big claim, correct?
Yeah, that's right. Interestingly was the way they assessed the pain and suffering damages in this case. So the plaintiff had suffered a right elbow fracture and lost, I guess, functionality as a result of that.
But that's confined more to the New South Wales way of doing things, Jess.
It's kind of analogous to how the Australian consumer law works. It's interesting to note how they assess that. But
the federal legislation.
Yeah, that's right.
Yeah. All right, we've gotten to the end of the show. Is there anything else you want to say, Nunzio?
No, look, I think it just highlights the difficulties with some of these public liability cases. And look, I just urge viewers to, give us a call because, we can assist you and give you the advice that you need, and we can go from there.
That's it. Jess, thanks for coming on board.
Thanks for having me,
Thanks for
Tony.
coming on board. Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes on YouTube. Go to our social media platforms, and always remember to stay safe.